just too short. Toastmaster, fellow Toastmasters, and guests. They were just a couple of kids. They are now just a couple of kids. One is 10 years old, the other is 6 years old. And all they want is a safe, secure, and permanent family. That's it. That's it. Tonight I want to tell you the story of XXG and NRG. We don't know their names. The confidentiality is being protected by the system. But I want to tell you about them because they made news a couple of weeks ago, and they're making news, and they present an interesting dilemma of public policy in the state of Florida. It all began in 2004. These two boys had been abused, neglected, and abandoned by their mother and their father. They both had ringworms. The baby had an ear infection that hadn't been treated since he was born. The 4-year-old had not learned how to talk. His greatest anxiety was how he should take care of, change the diapers, and feed his brother, because there wasn't anyone else at home to do that. So the Department of Children and Families took these two boys and they placed them. They did it because their parents had been removed from their family permanently. They put them in a foster home. They gave them a foster parent. There were two parents living in that home. One of the parents had custody, legal custody, of his son, who was 8 years old at the time. And in 2004, they began to live in this foster home. They lived there successfully. They thrived there. They did a remarkable job, these foster parents did. These kids had overcome all of the obstacles that they were given when they were born into parents who just simply didn't or couldn't care. So it came time for the father to go ahead and proceed in 2006 to initiate adoption action. He did. He filed a petition for adoption. And there were no parents. They had already been declared children wards of the state. So you would think it was smooth sailing, but it wasn't. Why not? Because the father was gay. Because the father was gay. The state of Florida said, like no other state in the entire United States, Florida said there is an absolute prohibition against gays adopting. That didn't stop the father because he went to court. He filed his petition, he went to court, and in 2008 the case was tried in Dade County. It took 4 days to try the case. Expert after expert after expert testified. Expert after expert after expert said the same thing. There is no difference between the effect upon children of a heterosexual family or a gay family. All of the experts said the same thing, except two experts who testified on behalf of the Department of Children and Families. One of them, his name was Dr. Walter Schum. And Dr. Schum testified, you know what, he said, I don't think that there should be an absolute bar. I think it ought to be decided on a case-by-case study. He said that on the stand. So he in effect nullified the state's position by his own testimony. The other person who testified was a George Riekers. He was a retired professor from South Carolina. He was a Southern Baptist minister whose testimony was totally discredited by court. This same George Reeker, by the way, made the news this year with the headline, "George Reeker is anti-gay activist caught with male escort rent boy. Escort says Reeker is gay." That was this man, that was his testimony. So his career as a witness has pretty much come to an end. So what about this situation? During the trial, we found out that people with HIV positive can adopt. We found out that people who are convicted of felonies can adopt. We found out that people who are substance abusers, whose past history of substance abuse goes back 5 years or more, can adopt. But there's an absolute bar against people who are gay or lesbian. That's what we found out. We found out that 3,454 children, when the case went to trial in 2006, were placed in foster care and couldn't find anybody to adopt them. 3,546 people, children. These men wanted to adopt and couldn't. Now, isn't that a travesty? The trial court, said this. The trial court said, "The reports and studies find that there are no differences in the parenting of homosexuals or the adjustment of their children. These conclusions have been accepted, adopted, and ratified by the American Psychological Association, the American Psychiatry Association, the American Pediatric Association, the American Academy of Pediatrics, the Child Welfare League of America, the National Association of Social Workers. As a result, based upon the robust nature of the evidence available in this field, the court is satisfied that the issue is so far beyond dispute, it would be irrational to hold otherwise. The best interests of children are not preserved by prohibiting homosexual adoption." That's what the trial court said. Of course, the story didn't end in the trial court because it went to the 3rd District Court of Appeals. And what did that court say? By a unanimous vote, everyone on the panel agreeing, the trial court's decision was upheld. And so Florida now is saying that it is a violation of equal protection of the laws to prohibit gay adoptions in Florida. Does it go to the Supreme Court? Does the law get changed? Policy decisions that we all have to consider. I ask you though, why in the world were these children denied the right to a permanent family? Mr. Toescast.